Remember if it was.
Well, let's, wait. Let's not guess. The 8th was Sunday.
Yes, sir.
The 5th would have been Thursday.
Yes, sir.
You got the machine on the 3rd, on Thursday, the 5th.
Yes, sir.
You didn't have any positive blows with it on the 6th, right? You didn't have any positive blows with it on the 7th. Wait, let me finish.
Yes, Your Honor. So again, just briefly, February 5th, Ms. Greathouse was ordered to obtain the sober link, which she did. I received an email February 8th indicating that Ms. Greathouse was positive for alcohol 7:27 p.m. at 0.019%. For counsel and for yourself, Judge, anything below a 0.020% does not require a reblow, and therefore no reblow was required at that time. On the 9th, as listed on the sheet that counsel has been provided, as well as yourself, Your Honor, Mr. Hunt does have this information as well. Beginning at 11 a.m., Ms. Greathouse was positive at a 0.029%. She called House Arrest Services claiming this was due to brushing her teeth. House Arrest Services did inform her to continue to blow as required. So at 11:17, she was and this is a typo on my part, that was 0.023% at 11:17 a.m., Your Honor, again, my typo. At 11:34 a.m., she was 0.23, 11:53 a.m., 0.017, again, under that cutoff, no more reblows were required, but resumed to be positive at 3:26 p.m. at 0.020, 3:44 at 0.013, under that cutoff, no further blows required. Continued to be positive that day, 7:22 p.m. at 0.023%, 7:40 at 0.022, 7:57 at 0.019 under the cutoff. Continued to be positive that day at 11:22 p.m. at 0.025% and 11:39 p.m. at 0.018% under that cutoff. Then on the next day, February 10th, she was negative for her morning blow. However, resumed being positive at 11:27 a.m. at 0.023, 11:44, 0.017% under that cutoff. Continued to be positive that day, 3:27 p.m. at 0.040%, at 3:44, 0.033%, at 4:02 p.m. 0.027%, 4:19 p.m. 0.021%, at 4:37 p.m. 0.016 under that cutoff. She did need to be positive for alcohol, however, again, under the cutoff at 7:29 p.m. and 11:18 p.m. The following day, February 11th, she was negative for her morning blow. Positive again, 11:25 a.m. at 0.025%, 11:43 a.m. at 0.021, and at 12:02 p.m. under that cutoff at 0.016. She continued to be positive under that cutoff at 7:11 p.m. at 0.019%. And at 11 p.m., she did fail to blow. An hour and 55 minutes later, at 12:55 a.m., she did blow, and she was all zeros on her late blow from 11 p.m. Last night. In the meantime, she did call House Arrest Services, and she claimed that her device was malfunctioning because it was requiring her to continue to blow. House Arrest Services did inform her that as long as it told her to reblow, that she needed to. This is what happens when we're positive for alcohol. It's going to have you blow until you are under that cutoff to ensure that it isn't environmentals like toothpaste and all the other excuses that sometimes we hear. But the one excuse that Ms. Greathouse used while brushing her teeth back on February 9th. I did ask them to send over her contract as well that she signs with them that indicates that she agrees to wait at least 20 minutes after using any mouthwash or any product containing alcohol, such as, but not limited to, hand sanitizer or any other topical substances that may include alcohol like cologne, perfume, bug spray, before she submits a test, as well as she agreed to submit to required tests if requested by the device after a sample had been submitted. There is no issue with Ms. Greathouse continuing to blow. But again, it's not a malfunction of the device. Mr. Hunt here is to do his testimony. It's because of the detected use of alcohol that she had to continue to blow, Your Honor.
Okay. Do you have any questions of Ms. Wiles?
Do I?
No, you're a lawyer.
Ma'am, you're not technically prepared to testify reliable as device is, correct?
I would leave that up to Mr. Hunt, sir.
The answer is no. You're not totally qualified. My question is, Mr. Hunt.
Okay. Mr. Hunt, I'm going to ask you to raise your right hand, please. You solemnly swear or affirm the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
Do you want to ask him some questions?
I'm going to ask him just a brief question in relation to an email, and then I'm happy with Mr. Longton, of course, to ask Mr. Hunt any questions. Mr. Hunt, you and I had talked on the phone. I asked you to review those blows from Mrs. Greathouse in reference to the possibility of that device being defective. And you indicated to me that as a knee-jerk reaction, you did feel that it could be a malfunction of the device, but that you wanted time to look at those blows and make, of course, a more professional decision. And you indicated to me in the email, I'm going to ask you if this is correct, that in looking at each single event, these are consistent with drinking. Is that correct?
That is correct, yes.
Thank you. No other questions, Your Honor.
All right. Do you have any questions of him?
Mr. Hunt. When my client calls Silverland to complain about the device, did she talk to you or to someone else?
She would have spoke to somebody in the monitoring center.
Who would she have spoken?
I would have to pull some calls to get names. I do have a note in here from Miss Hall, one of our monitoring room employees.
And that note says what?
That she called and stated the device keeps telling her to take to test multiple times. We advise her to just keep testing when the device says to. She stated that it may be because she smokes cigarettes. We advised her to reach out to her officer if she has any questions about the report.
What else do you have in your notes?
I have another note in here from a Miss May that says that the client called and stated she brushed her teeth and then left the house and tested on her device.
Do you have any other?
Those are the two notes on her account.
Do you have any notes from your staff indicating that they spoke to her about having the device recalibrated?
I do not know.
How often do these devices need to be recalibrated?
The devices are recalibrated after 1,500 tests have been taken. This device, I'm still waiting to hear back from the manufacturer because this was kind of short notice. But this device has, as of right now, 1,448 tests remaining until calibration, which indicates to me that the device was recently calibrated before given to Ms. Greathouse.
Isn't it true that these devices sometimes fail before reading 1,500 tests?
It's technology, so yes, that's certainly possible.
Isn't it true that it has happened and you have a record of these devices failing?
Yes.
So you don't know whether these test results are accurate or not.
But I mean,
You don't.
no, I do not. No.
Got nothing further than this call.
Do you have any other questions?
Nothing further, Your Honor. Mr. Hunt, is it possible to send a device into the manufacturer to determine in this circumstance if this is a device failure or not? Would there be a definitive answer?
Yes, absolutely.
Thank you.
Well, Mr. Hunt, the question is, if you send it back to the manufacturer, can they tell definitively whether or not it has been failed? Are you technically an expert that you could tell us if that's true or false? That the manufacturer can tell us definitively whether or not it's been failing?
I would be able to recite the report that was given, but no, I'm not an expert in device calibration. No.
So we don't know whether or not the manufacturer's report would be definitive or not, do we?
We don't even have that report yet to determine if it's definitive.
I'm sorry, guys, it's just totally cross it down.
Wait a minute. I want to interject.
I wasn't done.
Yeah, let her finish first. Go ahead. You want to ask a question?
Yeah, I had a follow-up question to that, but
Go ahead.
Mr. Huntington chimed in. Mr. Hunt, and it actually alluded to actually what Mr. Longton was. So if we send that device in and the manufacturer reviews the device, and we get that report back, that then, piggybacking off Mr. Longton's question, them being the expert, because that is their device, would we know if it malfunctioned or not?
Yes, correct.
Thank you. And I am done now.
And read the conclusion that he drew in the email again. Will you do that for me, please?
I can actually read that in whole. It says, good morning, Ms. Wilds. As we discussed on the phone, I went ahead and did some math to figure elimination rates. And these events are consistent with consumption. I have a consolidated report attached, and I also have a detailed report covering her positive dates from 2/9 to today. Knee-jerk reaction, seeing the mix of positive and compliant, was device failure, but looking at each as a single event, these are consistent with drinking. If you have any questions, please let me know. And it is signed by Mr. Hunt.
All right. Do you have other questions?
I have none. I had my comment, that's it.
Okay. Raise your right hand, ma'am. Solemnly swear affirm under penalties of perjury the testimony you give in these proceedings will be the whole true self you got. Okay, go ahead.
So what happened during the earliest possible?
I'm sorry, I didn't hear the question.
What happened with sober starting with these early possible days like February? What happened?
On the night, so I had taken a couple of days off since the last time I was in court and I stayed home. And then I went back to work that Tuesday, I believe, and I'm in my car a lot. So when I left this morning,
Wait a minute. Which morning are you talking about?
the 9th, I believe that was Tuesday.
Well, the first one said she was positive for alcohol at 7:27 PM on February 8th.
Talk about February.
8th. What day of the week was that?
February 8th would have been a Sunday.
Honestly, Sunday I was at home with my kids. We played some games, had the football game on. I got them to bed because they had school the next day. And then, so it must have been Monday then.
February 8th is the thing.
Okay, so then starting that Monday, I had gone back to work, back into the office, driving around throughout the
So the
day.
question is, what happened on February 8th at 7:27 PM?
No idea. You know, I didn't ask, I don't remember that it asked me to retest. Honestly, that was on Sunday. I don't remember.
Go ahead. On the 9th, you went to work. What time did you go to work?
I left my house at about 10:45.
Okay, where do you work at?
The office is in Allen Park, but I drive clients around or meet them at different houses. I do real estate.
Okay, so,
So on Monday, I had a client that, well, I went to the office first. We had an 11 o'clock Zoom. I did the Zoom and then I left. I met up with the client, so I did a bit of driving around. When I had gotten the first one, I brushed my teeth, left the house. I do smoke cigarettes, so when I called, I didn't claim that it was because of brushing my teeth. From my recollection, that was the first time it had asked me to retest. So when it happened, I called right away and asked about it.
Who?
I called house arrest. And I said, this is asking me to retest. And so I had asked questions the day when I signed the paperwork, when I got the device, and like Ms. Wilds had explained, like they did kind of go over everything. That was the day that I was in court. Did I necessarily remember the 15 minutes before and all of that stuff? No, yes, I did sign it. There was a lot going on. It was high stress, high anxiety. She went over it.
Let's keep.
Okay, so this day, all day I was driving around clients and I picked my kids up at this 3 26th time, I was with my kids. We went home, we had dinner. That was on Monday. They didn't have any sports that evening.
When is the last time you consumed heavy alcohol? Is it before February 8th, 26?
It was. Yes, it was in December.
Last time you consumed alcohol?
Yes, sir.
Did you consume alcohol on February 9th any time?
No, sir.
So, on your device, when you blew at 326 and 344, did you see these readings on your device?
No, sir.
You don't see these readings?
No, sir.
They don't. And we're, okay, so you just
So I was
tested
doing a
it.
retest. No, sir.
And when you're asked to reblow,
Yes, sir.
when were you asked to reblow?
Tells you to wait 15 minutes.
Right, so on February 9th, how many times were you asked to reblow?
The 9th. Felt like every time I did it, that's why I called. And then I wasn't asked to reblow on the 10th in the morning. and I
Let's
think
stick with the 9th.
Okay, so every time, and I had called that day, and I called house arrest, and I said, it keeps asking me to reblow. What could the reason be? She said I could bring it in and have it recalibrated, and then I had.
Did you, well, okay, go ahead. I'm sorry.
So then the next test, I believe, did not ask me to reblow. And then the one in the evening, I think did ask me to reblow, and then the next day, it didn't in the morning, and then it did a couple of times throughout the day. I think that one was the day that it asked me multiple times, or maybe not.
Let me ask you a question.
Yes, sir.
I ordered you to go and get the sober link the day you were in court. That's February 5th, right?
Yes, sir.
Did you go on the 5th?
Yes, sir.
Did you have any problems when you blew into the machine on the 5th after you acquired it?
The first machine they gave me was not working, so she gave me a second one, and then
Before you left?
no.
Wait a minute, slow down. Let's slow down. You went over to house arrest on the 5th
Yes, sir.
in Livonia.
Warren.
Warren, I'm sorry. Warren,
Yes, sir.
you said she replaced the machine?
The first one she gave me was not working.
And did she replace the machine before you left house arrest?
Yes, sir.
Okay, so you went back from house arrest on the 5th, right? With a workable machine, at least in your mind.
Yes, sir.
Did you have any problem when you blew in that machine on the 5th?
No.
Did you have any problem when you blew in that machine on the 6th?
On this, I don't remember if it was.
Well, let's
What was the
wait,
date?
whoa. Let's not guess. The 8th was Sunday.
Yes, sir.
The 5th would have been Thursday.
Yes, sir.
You got the machine on the 3rd, on Thursday, the 5th.
Yes, sir.
You didn't have any positive blows with it on the 6th, right? You didn't have any positive blows with it on the 7th. Wait, let me finish. You didn't have any positive blows on that machine on the 7th, did you?
No, sir.
And when you woke up in the morning, when is the first time you tested on the 8th?
Would have been between 6:45 and 7.
Did you have any positive blow on that time, on that occasion? Well, any problem with the machine testing inappropriately until at least 11 o'clock on or about the 9th of February?
It was the 8th.
Okay, you're right.
The only issue.
Wait a minute, slow down, my mistake. On the 8th, you blew positive at 7:27 PM, right?
Yes, sir.
How many times did you test it on the 8th prior to the 7:27 positive blow?
I tested 3 times.
Any problems with those results when you blew on the 8th prior to the 7:27
No, sir.
blow? Any problem with the machine when you blew on the 7th?
Not with a retest. The only issue I had with the machine that Saturday was that it wasn't turning on. And when it finally did power on, it had battery. So it wasn't that the battery was dead. That was kind of when it's. I didn't think much of it.
Any positive blow on the 7th? I'm asking you.
Oh, no.
Any positive blow on the 6th? Okay. Okay. Anybody have any other questions on? Go ahead.
Your testimony been completely candid? Correct.
You got to keep your voice up for me, though.
Up,
Yes.
When you heard, has your testimony been completely candid?
yes, sir.
The last time you had a drink was in December.
Yes, sir.
You willing to take the polygraph?
Yeah, we.
Your Honor, they're much more reliable than they were when you and I started practice law. And Taylor Police Department has a polygraph, and they're more than happy to pay for the polygraph. Because otherwise, you're going to make a decision based on a device that could well be defective.
It could be, and if I am not satisfied by preponderance of the evidence that she consumed alcohol, I'm going to find her not guilty. No, wait, just wait. Let's not. I don't want to talk about polygraphs. You ask your next question. Mr. Hunt, I want to ask you one while he's thinking.
Yes, Your Honor.
I want to make sure I understand. You said maybe every 1,500 blows it has to be recalibrated. Right?
After 1,500 blows, yes, is due for recalibration.
You said this particular machine, based on your inspection, still had roughly, I think you said, I want to double check, 1,444 blows left.
1448.
1,448 blows until the machine needed to be recalibrated.
Correct, yes.
Go ahead.
Mr. Hunt,
Yes.
last year in 2025, were there machineries that turned out to be defective before there were 1,500 blows?
I'm sorry, can you say that again?
Last year, January through December of 2025, were there devices that turned out to be defective and needed calibration before 1,500 blows?
Yeah, it's technology. Things can fail. That's absolutely true.
And you had devices that did fit, correct?
Yes.
DNA open today?
But on-site is, yeah.
Good.
Yeah.
What else?
Your Honor, I have the greatest confidence in my client that she's telling me the absolute truth. I think it would be a horrendous miscarriage of justice to have her guilty based on what you've heard today from both her and Mr. Hunt. And I know you don't want to hear anything about polygraphs. I understand why the District Court of Appeals is clear about that. But in all honesty, when you and I practiced law, they were only 60% effective. Today, they're 98% effective. I'm more than happy to have her polygraph as a Taylor PD.
How do you explain the fact that this machine was working on the 5th, was working on the 6th, was working on the 7th, and worked until 7:28 or 27 properly on the 8th, and then all of a sudden she starts blowing positive, and now there's a problem with the machine?
And we don't have the testimony from the factory to answer that question as to whether it could work properly today, fail tomorrow, and work properly 2 days later. We don't have that kind of technical testimony. Mr. Hunt's already testified he relies on the factory for that kind of. When I told my car this afternoon to come here, my brand new Jeep would not start. I had to go back in, call the dealer, come back out. Eventually, it started. Who knows why? They don't know why. Who knows why, whether or not this thing fails every other day or failed all these times? We don't have the technical testimony from the factory. I don't have it.
I don't, this is not, we deal with these machines all the time, Mr. Longton. SoberLink devices are accurate. Once out of every 500 defendants will somehow, some way, when they get results like this, want to try to insist that there's something wrong with the machine. There's nothing wrong with this machine. They don't need to prove beyond a shadow of any doubt that that the machine is working accurately. It's pretty evident here. He told you what it needs to have to recalibrate or how often it needs to be recalibrated. He said it still had 1,448 blows left. It's clear it was working on the 5th, the 6th, the 7th. And based on these results, when you take them, I've got testimony from Mr. Hunt that it's consistent that the amounts would reduce like this. Yes, listen.
The prosecution relies on pattern consistency. Now ask yourself, if the machine failed, why would the readings decline gradually instead of fluctuating randomly? This is where legal reasoning meets practical inference.
I don't think there's any question in my mind but that she was drinking. Okay? I get this all the time. And there's no question in my mind that she was drinking. And I'm not going to order a polygraph. I'm not sure I don't want to send her for a test. But I'll tell you what, I'll send her for a test.
If she flunks, put her in jail. Because I'm confident she's not drinking.
If she flunks on this test, I will put her in jail and she will remain in jail. I will set a bond she won't be able to set because I've just then, in my view, as I believe now, I've had somebody commit perjury in this courthouse, and I don't think very kindly of that. So yes, let's have her go to on-site today.
Yes.
Now, I am not going to be here tomorrow, but I will be more than willing to Zoom tomorrow. And we can Zoom on this case at 9:30 in the morning or 10 o'clock in the morning. You available, Mr. Longton?
I will change my schedule.
We'll Zoom on this case at 10 o'clock.
What I could do is I can have them send it straight to the lab. It won't be a screen, which would probably be more preferable. I assume Mr. Longton would prefer that as well, since he wants the actual results. So she can submit to her test today at 4 p.m. on site, and they can actually send it to the lab. Now, those results won't be back tomorrow. Should be back Monday or Tuesday. Court's closed
What
Monday.
does trouble me though is, yeah, let's do that. I'll do that. We'll continue the hearing at 10 o'clock. Now, I'm going to give you one last opportunity.
Yes.
I'm going to let you go test. If that test comes back positive, as opposed to me finding you guilty right now, I'm going to set a bond you will not be able to make. Do we understand? Maybe you need to go confer with your lawyer. I've been doing this a long time, young lady. I can tell who's telling me the truth or not. I don't pretend to have every answer, but I'll tell you what, I'll compare my ability to determine somebody's credibility with anybody's. And I don't believe for 1/2 second that you're telling me the truth. And then if you go and test and I have confirmation that you've committed perjury in here, you are going to have a massive problem with me. It's going to be so big of a problem, you're not going to want to, you're not going to believe how bad it's going to be. So I think before I send you for that test at on-site, you need to go confer with your lawyer for a few minutes. And after you confer with your lawyer for a few minutes, if you two want me to still order you to go to on-site, I'll order you to go to on-site. But do this, listen, don't talk to him now in front of me. Go take a few minutes, but think very carefully about what you're about to get into, okay? Do we fully understand one another? Okay, all right, you guys go talk. We can reconvene in here in a few minutes. Thank you.
Are we all set with Mr. Hunt, Judge?
Mr. Hunt, unless we call you again, thank you very much for your testimony. Mr. Longton, do you need any more?
Of course.
From Mr. Hunt?
Your Honor, I only had one question.
Well, I'll tell you what, you go talk to your client and he'll come back in here. Will you Zoom back in at 1 o'clock and we'll reconvene at 1?
I sure can. Absolutely.
Perfect. Thank you.
Thank you,
Thank
Judge.
you, Your Honor.
Next, be seated.
Court's back in session.
All right, back on record, getting this files in here. Recalling Summer Lori Greathouse, 25F245-336.
Hold on, Your Honor, but Your Honor, I asked her when the last time she had a call. She excluded the fact that she's been drinking non-alcoholic beer and my question for Mr. Hunt would be, would that create a positive test? I don't think it would if manufacturer's representation as containers is accurate. It's almost 0% alcohol, but I don't know.
We're just gonna follow this little circle around. We're gonna follow the circle around. I just want to know, does she want to get tested?
Yeah.
If she does at 4 o'clock, I'm sending for a test, and we are going to reconvene here at 9:30 or 10 in the morning. If she doesn't, sounds like she's already changing her story. I didn't hear one thing about a non-alcoholic beer until you just mentioned it. Not one, not even close. There's no remote reference to a non-alcoholic beer. So this is what I'm trying to tell you. I don't want to sound like a know-it-all, but I've seen this movie. I've seen this movie thousands of times. And if she wants to go for a test, I don't mind sending her for a test. But I don't hear this nonsense about non-alcoholic beer. Now I'm hearing, Ms. Wiles, you're just walking in, about she's drank some non-alcoholic beer. And would it be positive? So I want Mr. Hunt. I asked Mr. Hunt to show up here at 1 o'clock. And I'm hoping he's going to log in now. Do you see anybody from house arrest out there, Heather?
I do not, Judge.
Do you have your phone, Beth?
I do not, I typically don't work vehicle.
So, I just see this perpetual denial. You know,
There is an alternative. That is that she's correct. And
there is an alternative, like there's an alternative that I could pogo stick to the moon too right now. I mean, there's a possibility that some Martian could come grab me. I mean, look, it's fine. We'll send you for the test. I'm only telling you, I have one set of bond in mind if I don't think that you perjured yourself. And I have another set of bond in mind if I do think you perjured yourself. Okay? And if I send you for a test and it confirms this on top of what I have, I will be 1000% convinced that you perjured yourself. In which case, I'm going to set the bond that I would set if I'm convinced that you perjured yourself. I don't have any problem with you going for a test. You want to go for the test? You go for the test at 4 o'clock. We'll reconvene here at 9:30 or 10. Mr. Hunt, I told him one, I didn't want to have to wait.
Your Honor, may I have another moment with my phone?
Yeah, you can have another moment, but
Your Honor, you've been very clear. So allow me.
I know. I'd like to think I'm clear. Do I have this other person's file here, Heather, this gentleman that just came down?
Yes, she just brought him